I'm John Jeffries, a chartered tax advisor and chartered accountant based in Melbourne, Australia. Cityrose Trading Proprietary Limited versus Booth. This case concerned a commercial dispute regarding GST. It was decided in the Supreme Court of Victoria on 19 September 2013. Most cases concerning GST disputes are with the ATO. This case did not involve the ATO in any way. Here are the facts of the case. In May 2006, Mr. Booth entered into a contract to purchase a property from Cityrose Trading at Sorrento in Victoria. The purchase price stated in the contract was $2,250,000. This is the total amount that Mr. Booth thought he needed to pay under the contract. However, Cityrose Trading was registered for GST, and this meant that the disposal of the property was a taxable supply for GST purposes. Mr. Booth was not registered for GST. In the contract, there was a special condition that related to the payment of GST. Cityrose Trading considered that this entitled them to require Mr. Booth to pay a further $225,000, being 10% of the price in the contract. Mr. Booth was informed about this extra liability just prior to settlement. Mr. Booth was unaware of the GST clause in the contract until his lawyers advised him about it. Mr. Booth was unhappy about paying the extra amount, but still proceeded with settlement. He paid the extra $225,000 under protest. This amount was held in the trust account of the vendor's solicitors pending resolution of the dispute. The matter was first referred to the Victorian Civil and Administrative Tribunal for resolution. This tribunal is commonly referred to as VCAT. VCAT decided that the GST clause was valid. However, it also decided that the contract should be rectified so as to delete the GST clause because both parties at the time of making the contract intended that the purchase price would be $2,250,000 and no more. Accordingly, VCAT found in favour of Mr. Booth, and he was not required to pay the extra amount. Cityrose Trading was dissatisfied with this decision and appealed to the Supreme Court of Victoria. Cityrose Trading had many grounds of appeal, but in substance it considered that the VCAT decision was wrong and that the GST clause in the contract was valid and operable. Mr. Booth contended that the GST clause was so uncertain as to be meaningless and it should be severed from the contract. In the alternative, Mr. Booth argued that the GST clause did not require him to pay anything extra. Emerton was the presiding judge in the Supreme Court. Her Honour examined the GST clause in the contract. For the sake of brevity, I will not set out the full wording of this clause. The clause commenced by stating that terms used in the clause that were defined in the GST law took the same meaning as the GST law. Her Honour concluded that the words and their context provided no resolution to the question whether it was the objective intention of the parties to impose a liability on the purchaser in addition to the purchase price. The reason for this conclusion was that the use of terms in the GST clause that were also defined in the GST law could not carry that same meaning in the contract, although the clause specifically directed that to be so. Put simply, the GST clause equated the consideration under the contract to being the value under the GST law instead of being the price. This produced an inconsistency within the clause that could not be reconciled. The GST law states that the GST payable on a taxable supply is 10% of the value of the taxable supply. The value of the taxable supply is the price of the taxable supply multiplied by 10 divided by 11. The price when the consideration is just money, is the amount of that money without any discount for GST. So, normally the consideration is equal to the price and not the value. The GST clause in the contract equated the consideration being $2,250,000 to the value, and this did not make sense because the consideration equals the price under the GST law. So, in equating consideration with value, the GST clause was internally inconsistent. Her Honour decided that trying to reformulate the GST clause so that it had a useful meaning was not possible. She said that the GST clause was so obscure it was incapable of any definite or precise meaning, and that the court was unable to attribute to the parties any particular contractual intention. Therefore, the GST clause was void for uncertainty. The clause needed to be severed from the contract. Accordingly, the court found in favour of Mr. Booth, and he was not required to pay the $225,000 amount. What information can we take from this case that will be useful for advising our clients? Don't fall into the trap of thinking that GST is simple because it is just 10%. There are too many GST issues litigated to take that rather complacent view. When parties enter into a contract or transaction, ensure that both parties know precisely the total of how much they are paying or receiving. Do this without regard to GST liabilities. How much does the vendor want to be paid in total? If it is feasible, the vendor should state, preferably in the contract, whether the sale will be a taxable supply for the vendor and the amount of GST that the vendor will need to pay to the ATO to satisfy its GST liability. This is for information purposes. It is not for the purpose of working out how much extra the purchaser must pay in respect of GST. That issue has already been dealt with when the parties decided the total amount that is payable under the contract. If the vendor advises that it is making a taxable supply, the vendor must issue a tax invoice, or the contract should be drafted so that it qualifies as a tax invoice. It is irrelevant whether the purchaser is registered for GST. If the vendor is registered for GST, it should issue a tax invoice. Make sure that you understand the way GST technically works. Do not rely on the layman's view of the way GST operates. This lack of understanding is frequently the cause of commercial GST disputes. Don't assume that the lawyers drafting the contract have covered off the GST issue correctly. Many lawyers do not advise on GST at all. This can lead to errors in the way GST clauses are drafted. Thank you for taking the time to watch this video.